Oh, I guess everyone can hear me, but anyway, welcome to members of the public, either present or online, and those watching at a later date. Welcome staff, presenters, and any attending chairs. Council briefings are recorded. Public gallery attendees' presence implies your consent to being broadcast. Recordings are available upon request. Health and safety notices. In case of an emergency, follow the building wardens to the nearest exit. They're all marked. The meeting point is across the road at Peace Park. Bathroom facilities are located opposite the chamber foyer entrance, over that way. Are there any other... Well, no, Peter's got a hand down. All right, fine. Any other acknowledgements since... No. Apologies. Not that we need to do anything with them. So I'll hand over to Michelle and Natalie to take us through the principles of the Treaty of Waitangi Bill. Thank you, ladies.
Morena koutou, thank you for taking another hour out of your day towards the end of the year to listen to us. I was going to introduce Nat, but you've already done that, and we've already had a mihi from two, so I'll just let Nat get into it, and then we'll open for questions, and then we can get into the discussion on whether we move ahead with drafting a submission or not based on the discussion. Kapai, handing over to you.
E tuau i te tuatahi. I te tuatahi ki a koe e te mea, aroha mai, kare atu mōhi o te kupu Māori. Nā i mahi te karakia i tēnei ata, o tira ki a koe e te whanaunga mō tōpuni ki a hau. O tira tātou katoa e hui hui nei. E mau ana koutou i o pōtai māngai mō tātou katoa. He tino honore ki te noho i wanganui i a koutou ki te kōrero mō tēnei kaupapa a tino whakahirahira. Kia ora everybody. I just acknowledge the Mayor for his karakia, too for welcoming us, and then everyone who's gathered here today as representatives of the community. It is lovely to be here to help you work through and get a bit more knowledge about what's actually quite a tricky subject, and also in quite a condensed period of time. So we're going to be racing a little bit, I think, in this workshop. So just by way of introduction, so my name is Natalie Coates. I'm from Whakatane, so I'm from Ngāti Awa, and also have connections to other iwi, but for the purposes of today, Ngāti Awa is my main one. I did grow up in Whakatane, went to Te Teko School, Whakatane High School, then went down to Otago University where I got my law degree and degree in Māori studies. I did a Masters of Law at Harvard University. I have lectured at Auckland University as a law lecturer for a couple of years, where I did Treaty of Waitangi sort of subjects as well as other subjects, including jurisprudence and stuff. But for the past 10 years or so, I've been a lawyer. I was a partner at a law firm called Kāhui Legal, which is based down in Wellington and Rotorua. But earlier this year, I went out as a barrister. So I'm an independent barrister. Been living back in Whakatane for the last 7 years, and my baby goes out to Te Kura Kaupapa Māori o Orini out in coastlands. So it's nice to be here, nice to see all of the faces that I see on signs every 3 years translated into kind of real life. And yeah, I guess in terms of how, if we could, oh, hang on, just flick. If we can flick to the next slide. I thought I'd just give a bit of an outline of how I thought today should run, but I'm open to taking questions, I guess, at any point throughout. You don't need to wait until the end. In terms of pitch, like, it's quite hard, I think, in any group of people, because you tend to have a pretty broad spectrum of knowledge, from those who know quite a lot about a subject to those who know very little. So the way that I'm treating this in terms of, I guess, the level at which I'm pitching this is, you know a bit about Te Tiriti o Waitangi and what's going on, but I'll keep it and walk through it kind of hopefully in a systematic way, so that if you need a bit of catch up, we can help catch you up as well. I think the only other thing I wanted to mention at the start is another hat that I wear, as I'm currently co-president of the Māori Law Society in Aotearoa. And I guess, so we've made submissions on this, and I have also been a vocal advocate in public and in the media against the bill. But I guess I just wanted to say that just means that I'm relatively informed about it, but feel free to ask any questions that you want, including challenging ones. I'm not here to necessarily pitch a particular perspective, but I will walk you through kind of a number of the really key, tricky issues. And all of this, I guess, will be obvious in terms of, the perspective I'm coming from. Most of it's around why it's a really bad idea for this bill to progress. But hopefully you'll see that that's coming at it from an academic perspective as opposed to a particular political or advocacy perspective, because what I'm really coming at it from is a legal and constitutional perspective. So this is kind of the broad outline of the workshop. I'm going to give a little bit of background and context to treaty principles in general. Then I'm going to go on to talk about what the treaty principles bill itself says. Hopefully you've read it. It's very short, but if we just it's like a one page. But if it's worth kind of being really clear, and if you've got any questions about what it means, we can go through it then. I was then going to talk about some of the key issues. So why is it problematic primarily? And then keen to have a wānanga and discussion with you guys about what the implications for you guys might be, because understanding that is really the basis upon which you will then make a decision about whether you submit in relation to it. So if I go on to the next slide, if that is possible, the battery's running out. Can you guys, are you just watching it? You're not watching it on your screens, are you? Just looking at it from it? Oh, you can see it on your screens as well. Okay, so if we just go to this. So hopefully you've all read Te Tiriti o Waitangi, the Treaty of Waitangi. I'm not going to spend much time on this at all, but it is worth bringing it up and just talking about it for a minute or two, mainly because the concept of the principles of the Treaty of Waitangi must come from the treaty itself. Right? Otherwise, it's not the principles of the Treaty of Waitangi, it's the principles of something else. Right? So the whole concept of the principles of the Treaty of Waitangi must have some resonance in the actual text, spirit, intent, or something that has to do with what Te Tiriti o Waitangi actually says. Right? So it's worth just reminding ourselves, so it's front of mind, what Te Tiriti o Waitangi and the Treaty of Waitangi, both versions, actually say. So in the English version, you have the chief ceding sovereignty to the Queen. These are kind of like the shortened version. That's Article 1. Article 2, you have the Queen effectively confirming and guaranteeing the full, exclusive and undisturbed possession of lands, estates, forests, fisheries and other properties which they may collectively or individually possess so long as it is their wish and desire to retain the same in their possession. So Article 2 of the English text of the Treaty of Waitangi is really around kind of the protection of proprietary rights in all its form, at a basic level. The third article of the English version of the Treaty of Waitangi is the extension to the natives of her royal protection and imparting to the natives all of the rights and privileges of British subjects. Right, so that is the English version of the Treaty of Waitangi. In terms of the Te Reo version, and it's worth just pointing this out, I think, is that the Te Reo version is the version that almost all of the rangatira, Māori rangatira, signed. Right, so 540 signed the treaty, and I think it was 29 that signed the English version in Waikato. But the overwhelming number of signatories was to the Te Reo version, which is important, I guess, in the context of why Māori are usually saying ona Te Tiriti o Waitangi and not the Treaty of Waitangi. So in terms of the Te Reo version, the chiefs gave ka wanatanga to the Queen. Right? And as you may know from history or whatever reading you've done around this, ka wanatanga is not a natural Māori word. It's a transliteration of the word governorship. Right? And so governorship, there has been lots of academic scholarship about what the chiefs may have thought that meant and what they may have been familiar with in terms of governing at the time. right? And we'll talk through that a little bit more. But importantly, I think it was clear that a form of power was guaranteed to the Queen of some form. Quite a lot of the jurisprudence around it has been that that was intended to be in relation to their own people, right? Not Māori, particularly because you have Article 2, which continued to guarantee the chiefs, rangatira, tino rangatiratanga. Right? And that tino rangatiratanga word is really important because rangatiratanga means chieftainship, and so there was an absolute guarantee of chieftainship or the retaining of some form of authority over their whenua, lands, kāinga, homes, and taonga katoa, all things that they hold dear. Right? And both had rights of preemption, which is sort of less important for the purposes of what we're looking at now. So importantly in that version, whilst a power was granted to the Crown of some form, it was qualified by the retaining of tino rangatiratanga by Māori. The third article, the Queen said they'll tiakina. Tiakina means like tiaki, look after, right? So it's again that idea of protection inherent in that. They'll tiaki ngā tangata Māori katoa, we'll look after Māori. And we'll also, in Māori, it effectively grants them the same rights and privileges as those from Ingarangi or England. So that's a very brief whirlwind trip through the text. I think one of the important things, I guess, that has come up a number of different times is the irreconcilability of these two texts and what they're saying. Right, which is partly why you get that reference to the principles of the Treaty of Waitangi. One of the interesting pieces of scholarship that has been coming out now, including by Dr. Ned Fletcher, who wrote a PhD on the English text of the Treaty of Waitangi, is that he talks about how actually he thinks that they're more reconciliatory than most people think, i.e. that when the English version was signed, sovereignty was not how we understand it today, which is this power to do whatever laws that pass, whatever laws you want to pass. But sovereignty back then was a more qualified power because they understood that when you come into a place, often you do have to deal with other, you're a minority and you do have to deal with other body politics in the area. So I mean, that's just sort of a side note around the kind of academic literature developing in relation to these two texts. So if we can go to the next one, important to keep that in mind again so that we have an idea of what Te Tere Tio Waitangi says. Yes?
Back there in Article 2 of the Reo version,
yeah.
You talked to, I know whenua is, what's it, kāinga?
Homes.
Okay.
Yeah.
Tanga.
And taonga. Taonga means like treasured thing.
Okay.
Yeah.
Preemption.
So preemption, I've sort of glossed over that, but basically both texts guaranteed if you're going to sell your land, you have to sell it to the Crown. So it was a monopoly right to try and get Māori to sell their land. And so the issue was, part of the reason for Te Tere Tio Waitangi was you had like the New Zealand company and a whole bunch of companies coming over, giving muskets and things to Māori and saying that, yes, we're transferring all this land. But that was problematic because the legitimacy of those transactions were questioned. And so one of the things that the Crown wanted to do was put themselves in as the middleman to be like, all land comes through us and we'll sell it to everybody else. And that helped them get some revenue to help start the country.
So that was in the Te Reo version too, that all land has to go through the government?
Yes, yeah, yes. And as that was in the English version as well. Yeah. Yes.
According to Sullivan, he says that the idea of preemption really was there to protect Māori from being ripped off by settlers. Is that?
I think that's right as well. I think it was there were multiple reasons for that particular thing. So it was a protective right. I mean, there is also discussion at the time around what Māori actually thought a transaction meant in that sense, in terms of coming at proprietary ownership with a totally different cultural view to the settlers. And so I think there's probably some truth in that, but I think there's also truth in the Crown needing revenue to be able to establish itself and implant itself in Aotearoa. Nando.
Thank you, and welcome back.
Kia ora.
I was just going to make a point that in terms terms of how Waitangi, so I read William Colenso's eyewitness account of the signing at Waitangi, and he's really clear that Governor Hobson says that what the Queen was asking for is the right to govern Europeans or English people who'd settled here. Thank you. So, Colenso's really clear in his eyewitness account of the signing that Hobson says to the rangatira that the Queen is asking for the ability to govern English people who'd come here who were unruly, and she had no power to rule over them without the consent of Māori, essentially.
Yeah, and that makes sense in the context of the time, right, where you have Māori as the predominant majority, vast majority population, and you have unruly settlers as being an issue. And so if you, I guess, read the Māori text, one of the key issues that's been debated over time is what Māori thought they were giving up, right? And I think the clear, overwhelming kind of literature that comes out about that is that they didn't think they were giving up absolute authority and control to the Crown. Right, that rangatiratanga was certainly guaranteed over their own affairs effectively and their own lands, of which at that time they owned most things. And so I guess that's where kind of the bite comes in terms of those two texts as we interpret them today. So I'm going to talk a little bit now about the background and context to the concept of the treaty principles. So we're moving on from the text to now this idea of the treaty principles. So this was an idea that was first introduced into legislation in 1975. And so the first time we saw it pop up was in the Treaty of Waitangi Act 1975, and that was the piece of legislation that established the Waitangi Tribunal. And if you think back to the context of the 70s, the 60s, right, that was a time where there was great sort of political movement and agitation and hikoi and all of that, not only in Aotearoa but also around the world in relation to women's rights, gay rights, Indigenous rights. It was kind of time of civil action that was occurring. And Aotearoa certainly wasn't immune from that. So part of the Treaty of Waitangi Act 1975, the impetus came through things like that big Māori land march led by Dame Whina Cooper, and ultimately Māori being in a situation where they were landless. There was a whole generation of educated ones that had come through universities that actually realised that they didn't have the language and that culture was fast kind of becoming assimilated. And so you had this really staunch group of people coming through kind of demanding better from the Crown in terms of honouring Te Tiriti o Waitangi. You also had a number of politicians in there, Māori politicians in there at the time, who were also pushing people as well. And so you do start to see Te Tiriti o Waitangi first introduced into legislation in that piece of act, in that act. And what it did was it charged the Waitangi Tribunal with inquiring into breaches of the principles of the Treaty of Waitangi. So you basically have this body for the first time having to be like, okay, grappling with and assessing Crown action in relation to Māori against this threshold of the principles of the Treaty of Waitangi. It was undefined, right? It was, the principles was and has always since, until this year, been undefined in legislation. Since then, you start to see references to the principles primarily of the Treaty of Waitangi being pepper-potted throughout legislation in Aotearoa. And of course, you've got the Local Government Act 2002, which refers to it. You've got the Resource Management Act. You've got the State-Owned Enterprises Act. You basically have Te Tiriti o Waitangi kind of across a whole spectrum of different legal areas of interests, primarily in relation to resources, environment, kind of social issues, but it goes beyond that as well. You also have the courts developing kind of parallel common law alongside it, where they've read Te Tiriti o Waitangi in as being relevant to interpretation of legislation, even where it doesn't mention it at all. Right? So Te Tiriti o Waitangi, unless you're expressly saying it's not relevant, can be used as an interpretive tool when looking at legislation. And the whole thinking behind that is the Crown signed up to this, we're going to presume that they intend to honour it unless they're saying otherwise. So that's kind of where the jurisprudence has developed, and we see it occurring in a vast array of different places. Yes.
When you say legislation, I mean, in our system, who makes the law
Yep.
is government,
Yep.
and it is interpreted by the courts.
Yep.
Would that be, that's
Yes.
fair comment?
Yes. Yeah. And so I think it's also a fair comment to say, like, if we think about what we've just talked about, which is te tiriti o Waitangi, like, we exist and are operating in Aotearoa in structural breach of te tiriti o Waitangi, right? Like, Parliament is operating as sovereign. They are passing laws for everybody, right? And in terms of how tino rangatiratanga is operating, right, that's often pretty limited to the cracks of legislation these days, right? And so there is tension that exists there between, like, how we're structured as a country and what te tiriti o Waitangi actually says. Like, that just needs to be, I think, acknowledged.
Well, I'd just argue that I'm not sure it's as simple as that, because there's a lot of law exists that's not statute law. I mean, the whole of the common law predates statute law. And if you think about the Evidence Act, for example, that was a codification of evidence, laws around the evidence in court. But before the Evidence Act, there was still law that governed it. It was just, it hadn't been codified by the Parliament. It was case law that judges had developed. So I'm not sure it's as simple as that Parliament makes laws and judges interpret it.
Sorry, I think that's right as a simple proposition, but I'll agree. Of course, we have a whole body of law that statute law doesn't cover, framework that the courts are increasingly grappling with, how that fits in and what that means for us as a country.
I mean, the issue I just raised is so key that we could be here all day just debating.
Yes, and I don't think it's critical.
Well,
to
it
what
is.
you need.
It is in a sense, because the principles. I mean, was it a parliamentary thing in 1975, or was the courts?
No, it was Parliament. Parliament directed that the courts grapple with it, and the courts have done what they have been told they need to do, which is apply it in different contexts.
Yes, but isn't that? I mean, the bill itself says it's the Parliament that should come up with the principles.
Yeah, and
I didn't read it properly, but anyway.
Yeah, I'll get to what the bill says.
I mean, the whole
itself.
issue about who makes laws happens to be the basis of a report by the New Zealand Initiative. It says who makes the law, and they're claiming. I mean, I haven't read it, but they say that the Supreme Court has overstepped its role. So I'm just not sure if it possibly bears on this. But anyway, look, I know we could be here all day.
Yeah, I mean, yeah, and happy to talk to that if that's particularly relevant. I mean, I'd argue the Supreme Court is doing its fundamental function, which is interpreting how things apply to different factual contexts. But, yeah, anyway, we'll carry on. So in terms of the treaty principles, so as I've sort of already said, I think they are often considered a pragmatic way to try and bridge that irreconcilable gap between the Māori and English text of te tiriti o Waitangi. The concept in and of itself is not uncontroversial, right? So Māori have long... many Māori have long rejected the idea of the principles, because what they say is that instead of trying to reconcile this gap, we should just be honouring te tiriti o Waitangi, right? And so that's the text that they signed, that's the text that should be honoured, that's the text that has long been breached, and we need to get to a state of better honouring that. So I guess that's just a point that's worth making. In any event, there has been, over the last 50 years, a body of significant jurisprudence that has developed around what the treaty principles means, right? Because courts and the tribunal have had to, because they have had cases come to it and they are mandated to do this, have had to interpret that particular phraseology and apply it to a whole bunch of different contexts and factual situations before it, as they do in the normal course of affairs, right? Case by case, you come, you get evidence presented to you, you have usually the Crown and Māori bringing evidence about what they mean and grappling with a whole bunch of kind of history and experts and all of that. So they, as independent third parties, have had to develop a body of precedent around what those particular principles mean. There is now, I think it can be said, a relatively high degree of certainty around what those principles mean. Now, they might apply in different contexts, But you generally have these sorts of words coming out in relation to what those principles mean. Principle of partnership, right? So Te Tiriti intended a relationship of partnership in some form. You have the idea linked to partnership of acting in good faith towards each other. The idea of active protection has come up. So that is when the Crown has assumed control, which they have done, they still have that obligation to recognise and protect the rangatiratanga, taonga, proprietary rights, etc. of Māori. Other ones are options, good government, equity, redress, and tino rangatiratanga. It is correct to say that they have evolved over time, right? As courts and the tribunal have heard more, as they've had to apply it in different contexts. And actually, I think there's more of a move at the moment than there used to be around actually centering principles and concepts embedded in the text itself, as opposed to kind of more abstract ones looking at what was the intention and spirit of Te Tiriti o Waitangi. So that one at the end, tino rangatiratanga, has become a principle that is increasingly talked about, which is clearly embedded in the text itself, when it didn't used to necessarily be so prevalent. So there is quite a period of time that these ideas have been sort of circulated and been developed by the courts and the tribunal. Yeah.
Say something about that.
Sure.
With those things of partnership, good faith, etc., do you find that if we keep going back to the absolute meaning of every sentence and every word, that you miss the ability that as we go through the involvement thing between the relationship and this fact of good faith, that actually at some stage we need to evolve everyone's standpoint to come to a unity thing. And I wonder if this thing where you say that the government should only govern over the English people and their laws and iwi do their laws, that you're actually getting to a situation where the good faith gets eroded because everyone's standing on their own little soapbox, and I don't know what I'm trying to say. If we keep going to the original meaning of the word, do we lose the ability to evolve in good faith and come together as a unified partnership of two separate people?
I think if you look, and I mean, there's been lots written about this particular issue, and I think Te Tiriti o Waitangi and the Treaty of Waitangi are both ultimately relational documents. Like, they're intended to talk about how power, authority, and a relationship exist in Aotearoa. Now, we don't currently exist, or I would say, like I kind of said before, we don't currently exist in an environment where we are honouring Te Tiriti o Waitangi and how it was specifically envisaged we would work together and live together as a nation, right? We just don't currently have that scenario. But I guess the whole point of it is that, and what Māori have been calling for is better recognition of what was guaranteed to them, and can we move together in a unified way, but both still respecting each other's place in the world?
I guess, like that was hundreds of years ago that the treaty was evolved and for specific reasons of the new settlers being unruly and all that, stealing land and all that sort of stuff. And I don't quite agree with why the new treaty bills come out, but is it a chance where we can actually say, let's evolve this and actually come together and forget about some of the reasons why it was brought out, but actually evolve this more than 1975, so we actually work together, respecting each other. And I know that's idealism, and idealism hardly ever works.
I mean, I don't think the thinking behind it is necessarily bad. Like, I think that there is an important national dialogue that needs to occur between Māori and the Crown and others about how we embody Te Tiriti o Waitangi going forward. I think the problem in this bill, and we'll get to why it's problematic, is that this doesn't bear any resemblance to Te Tiriti o Waitangi. It was developed in the absence of Māori, and so you've got really just like one little pocket of people promoting something, and it's not about unification, it's about like, we will suppress your rights. And so I think the intention and idea of having a kind of broader, more modern understanding of how we express te tiriti o Waitangi and a conversation about that so that there can, we can work out a unified way going forward that develops and evolves over time is a good one. I think this is just not the mechanism or way of doing that.
Item 6 there, would it be fair to say that when any two people or peoples come together, most of those things would apply? I mean, it would just be a common sense way to approach any collaboration, and I guess the difficult one is the tino rangatiratanga, which comes down to the sovereignty question here. Is that?
Yeah.
It's pretty obvious to me that yes, partnership, good faith, active protection options, good government, they're all good things to have in any relationship.
Yeah.
Tino rangatiratanga is a little bit, that's that Article 1, no, I'm not disputing Article 2 or Article 3. Article 1 is the sticky one.
I actually think for the Crown, Article 2 is the sticky one because that's where the guarantees were made. That fetters their power, right? So it's how those two things operate together that is the tricky issue. Like the recognition of Māori rights, interests, rangatiratanga is what the Crown currently grapples with. So I think it's how they're read together because you can't read Article 1 in isolation from the fettering of what the fettering that has on Article 1. Okay, wait, next one. I'm just going to keep an eye on the time. Okay, so in terms of the Treaty Principles Bill, so I've just briefly talked about the treaty itself and then that concept of the treaty principles in general. I wanted to just briefly go through what the treaty principles actually says so that we can start to tease out, I guess, some of the issues with it. And I think the first thing to say about it is that we need to keep in mind that this is about, what it purports to be is a reflection of what the treaty says, right? So there's a difference between saying, if David Seymour or the ACT Party had come out and said this is a dishonouring of the treaty, or this is a reinterpretation of the treaty, or this is how we want to go forward in a way where we're removing Māori rights, right? That's quite different than saying this is a bill that reflects te tiriti o Waitangi and its meaning. So part of the issue is kind of the dissonance and disconnection of what they're suggesting from what te tiriti o Waitangi actually says. So in terms of Principle 1, right, so they've kind of tried to mirror the three articles. So they've got the three articles of te tiriti, they're trying to encapsulate that into three different principles. Right, so the first one is the principle of civil government, where they say the executive government of New Zealand has full power to govern and the Parliament of New Zealand has full power to make laws in the best interests of everyone and in accordance with the rule of law and the maintenance of a free and democratic society. Now, on the face of that, that doesn't sound that bad, right? And they're kind of doing what they're doing anyway. They're making laws, they're doing that. But I think you have to understand and read that in the context of te tiriti o Waitangi, right? Which didn't guarantee a full absolute power to govern and to make laws for everybody, but it guaranteed a form of authority, ka wanatanga, with the recognition of tino rangatiratanga as well, right? So that's where Principle 2 becomes really important, because the way that they've expressed the rights of hapu and iwi Māori is that the Crown recognises and will respect and protect the rights that hapu and iwi Māori had under the Treaty of Waitangi at the time they signed it. So we'll recognise your rights at 1840, but if those rights differ from the rights of everybody else, it will only apply to rights that are agreed in the settlement of a historical treaty claim under the Treaty of Waitangi Act 1975. So what that effectively says is we will only recognise Māori rights as being unique and different where you have a treaty settlement. Right, so rangatiratanga is stripped out of te tiriti o Waitangi completely. The recognition and protection of proprietary interests are stripped out from te tiriti, the Treaty of Waitangi completely, And all that Māori are left with, apart from being treated the same as everybody else, are treaty settlements, of which not all iwi have treaty settlements, and those that do were negotiated in a particular context, right? As you'll be aware of, because you've got 7 iwi here that have particular treaty settlements, right, and particular arrangements. So that is where the huge paring back of Māori rights and interests takes place in this particular piece of legislation. And I'll talk through some of the broader implications shortly. But if we just look at Principle 3, so that's the right to equality. Everyone is equal before the law. Everyone is entitled without discrimination to the equal protection and equal benefit of the law and the equal enjoyment of the same fundamental human rights. Also doesn't sound too bad, right? Like equality. These rights are already protected under the Bill of Rights Act. I think what we need to ask is this what Article 3 reflected, right? And I'll talk a little bit about that in a second. The other clauses, short clauses, say that these principles must be used to interpret enactment if the principles of the Treaty of Waitangi are relevant to interpreting that enactment. So in terms of what those principles are designed to do, anywhere that you see the principles of the Treaty of Waitangi mentioned in legislation, the courts and everybody will have to interpret it with those principles in mind and no other principles, right? Or reference to Te Tiriti o Waitangi itself. That effectively replaces Te Tiriti o Waitangi for all legal purposes, right? So this is designed to effectively stand in as the substitute for Te Tiriti o Waitangi within the law. And it's whether express or by implication, right? So where Te Tiriti o Waitangi is mentioned specifically, those will apply, but even where it's not, whenever you're thinking about Te Tiriti o Waitangi in relation to law, it is these principles that will become the substitute for what Te Tiriti o Waitangi might mean in that context. It does say that the Act doesn't apply to treaty settlements, so treaty settlements kind of have this ring around them as being preserved. And it interestingly also says nothing in the Act amends the text of the Treaty of Waitangi Te Tiriti o Waitangi. That's quite interesting because whilst it literally does not go down to Wellington and rub out like the words and amend it physically, what it does do is replace it for all legal purposes. Right, so there's a bit of disingenuousness kind of in that statement in that it doesn't physically amend the text, but wherever it's relevant, it will replace its relevance. So fairly extensive legal impact this bill will have. Now if we go on, this is what the tribunal has said about it in a report. So they looked at the first iteration of kind of David Seymour's policy articulation of it, and then they've also since looked at the text itself that was produced in the bill, and their assessment was if it was to be enacted, it would be the worst, most comprehensive breach of the treaty Te Tiriti in modern times. If the bill remained on the statute book for a considerable time or was never repealed, it could mean the end of the treaty Te Tiriti o Waitangi. So there has been fairly condemning statements made through that forum, which is specifically designed to look at whether something is a breach of the Treaty o Waitangi or not. Now, I just wanted to point out some of the issues that kind of immediately come to mind in terms of what this bill does, if we can go to the next slide. So the first one is unilateral amendment, right? So that is the Crown, without the free, prior and informed consent of Māori, one party to the treaty, just changing it, like seeking to completely replace what it means in law. Now, there is an extent to which the Crown kind of already does that a little bit when they add in a treaty clause and they say what it means or what intended effect it's supposed to have. But this is doing it just in a completely systemic way. This is how and what Te Tiriti o Waitangi means in a modern context and how it will be applied. There's kind of a reason that they've left it to the courts and independent third parties before, because they are not a disinterested party. They are a party to the treaty, right? So if you kind of if you step back from the idea of a contract, it would be like one party to the contract sort of saying, this is how I'm completely reinterpreting this contract that we both agreed and entered into. So that's that one. The second is that partnership and good faith relationships would cease to exist. Now, that's kind of a big, bold statement, but it's kind of what the tribunal has said, in that effectively, and this is something we'll work through in terms of the impact it would have on like you guys at a local level, it means that Māori are treated the same as everybody else in Aotearoa, and there's no recognition of the laws, Te Tiriti o Waitangi, and I guess the rights, proprietary rights, all of those kind of rights that developed, that pre-existed another system coming over to Aotearoa, right? So the idea of that relationship as being something that is special and that we need to engage and treat with Indigenous peoples in a particular way in Aotearoa would become codified completely in treaty settlements. Another issue is that the bill bears, well, very little, probably it should say, resemblance to Te Tiriti o Waitangi itself or its principles. So what it's attempting to do is to sort of cloak itself and say that it's Te Tiriti o Waitangi and that it reflects the principles, but it's a novel interpretation that many, including linguists and lawyers and the tribunal, etc., say just doesn't actually reflect either the text, the spirit, the intent, or the principles that have been developed over the last 50 years, right? So there's very little resonance with that. And in terms of, I've just sort of set out there, I guess, some of the differences between the articles. So Te Tiriti provides for bridled and fettered Crown power. Principle 1 makes it absolute. Principle 2 removes rangatiratanga guaranteed by Te Tiriti and limits it to only what's recognised in treaty settlements. And even though there's some resonance with equality, it still misrepresents what the guarantees in Article 3 actually says and expands them to apply to everybody. So it may be that we all agree that there should be protection and equal rights, but we've got another mechanism for that. That's different to what Te Tiriti o Waitangi might actually say, right? So there's a difference there, yeah.
Nā pera.
Oh, aroha mai.
Hello.
Hei, kia ora tātou. Hi, Natalie. Nā mihi mo nā kōrero. I'm not too sure whether or not everyone knows what the 3 Ps are and to which principle they apply to. So there seems to, I'm listening to you and how important this conversation is. So we do have the 3 Ps. If you are able to identify which of those Ps belong to which principle. I know there's partnership, protection and participation, just not sure. Principle 1 is around, Principle 2 is around, and Principle 3 is around. There's an assumption that we do know what the 3 Ps are, but I really kind of doubt not everyone at our table will know what they are.
Ka pai. So the 3 Ps, I think that the idea of the 3 Ps is kind of a bit outdated now. So the 3 Ps was a kind of document developed by the government, I think around 10 years or so ago, where they attempt to kind of like boil down the main principles of the Treaty of Waitangi, and they like defined it as partnership, protection and participation, which are kind of like resonance of the ones that I talked about, except there's a bit more of a nuance and expanded list to them now. But if you boil it down to those 3 Ps, right, and you measure them against what the Treaty Principles Bill is saying, partnership, not really in there at all, apart from through treaty settlements. Protection will protect your treaty settlement rights, and participation, provided it's in treaty settlements, that's how we'll recognise your participation, right? So it kind of strips back some of those ideas and really funnels all Māori rights into treaty settlements.
Just to follow up, so have those 3 principles been removed? The partnership, participation, are they still inside of our legal system identified?
I think there's some. I think they are there, but they're just more nuanced than just simply those 3 Ps. But certainly, what the Treaty Principles Bill would do is remove them completely and would replace all of the existing principles, including those 3 Ps, with the principles articulated in the bill.
Hapa.
Kia ora. I think of importance because treaty settlements seem to be the only way through which Māori rights are funneled. It's important to understand, I guess, that they were never intended to confine, limit or codify the present and future application of the Treaty of Waitangi. So treaty settlements, if iwi knew that treaty settlements were going to be the be-all and end-all of the Crown-Māori relationship, they would never have signed up to them, right? Because treaty settlements for most iwi represented a massive compromise around and was around the settlement of historical grievances. So while some treaty settlements do try and pave a way forward by having ongoing relationship redress, it was never intended by any iwi or the Crown at the time to codify like this is where the treaty relationship ends, right? They're a mere fragment of that, trying to reconcile our really ugly past, but they're never intended to be the ongoing future state of affairs. So I think that's really important because that's effectively where all Māori rights are being funneled into by this piece of legislation. Importantly, Te Tiriti would have no effect in legislation for unsettled iwi. So, for example, you have Ngāpuhi up north. You don't really have this issue so much here, but the whole of Ngāpuhi up north, wherever Te Tiriti or Waitangi is mentioned, they would have no rights whatsoever. And for those who are settled, for example, my iwi Ngātiawa, we negotiated at a pretty tricky time, 2004. I think didn't get the benefit of lots of the current relationship agreements that now exist in treaty settlements. And so if you're limiting Ngātiawa's rights to like just what was recognised there, all you would do is have the remnants of some relationship stuff out at the Rurimas, the Rangitaiki River stuff, and that's about it. It would mean that you can't engage with Ngātiawa in any different way than you do from the other people, your other constituents in this rohe, except what is enshrined in their treaty settlement, which, as you'll know, is relatively limited, right? So, pretty massive effects for the way that you engage with and treat with Māori. Those rights would become frozen at 1840 for closing on their right to development. So they recognise rights at that point, which is basically no rights because it's all now being codified in that treaty settlement space. What this would do, this piece of legislation, it would create significant uncertainty within the law, right? Because we'd be starting from scratch in terms of where Māori interests apply everywhere and having to grapple with what it means. So if you think about Section 8 of the Resource Management Act, for example, which I assume you'll be relatively familiar with in your role, perhaps, right, that says the Treaty of Waitangi must be taken into account by everyone engaging in resource management issues. What this would mean, effectively, is that unless there is a resource management kind of related agreement in a treaty settlement, that clause becomes irrelevant. So in terms of how, like, there'd need to be a grappling with kind of what Te Tiriti or Waitangi means in the context of that versus what other Māori rights are kind of protected in the legislation, how those intersect. Because kaitiakitanga would still be there within the other sort of section in the Act, but like grappling with how that all fits together and what that means for how you roll and how you act would certainly take some time to work out across all levels in which Māori are engaged with. One of the things at the beginning of the Act is it sets out a number of policy reasons that they're doing this. So one of them is around trying to create certainty, which interestingly the Tribunal and others have said this would have the opposite effect and create significant uncertainty. It also says it's around fostering a healthy national conversation. Everyone possibly will have a different opinion as to whether it's done that. It's certainly fostered a conversation, right? And there's a lot of information going out there, I think, from multiple different fronts around it. My thoughts on that is that the issue is that it's not kind of like it's not really an educational campaign about getting everyone up to date, right? It's premised on misinformation, I would say, around what Te Tiriti or Waitangi purports to say and trying to cast it off as an accurate interpretation, and it's just not. And then finally, this is sort of related to that last bit where it says we're not touching the text of the Te Reti o Waitangi. Whilst it purports not to do so, the effect is to do so. And so that's quite important as well. So if we carry on, I was hoping to have a bit of time for you guys to think about how it might apply to you, but I think we're short. So I've just dumped, because you know what you do best, right? You will be able to look at what the bill does and extract it to see how it applies. Yeah.
I can't speak on behalf of everybody or staff, but I don't think we're limited to 10 o'clock.
Oh, okay. Ka pai. We can keep going?
I can't speak on behalf
Yep.
of everybody, but I don't.
Sweet.
Steve
I think
thinks-
I've got a flight at 1 o'clock from Tauranga, but
Well, maybe
subject
not
to
1
that.
o'clock, but
Yeah, yeah.
Are
So
you
maybe
char-
another half an hour?
Are you charging us by the hour?
Actually, I am.
Okay, then 10 o'clock, that's it.
It's very important. We don't want to feel it's
Yeah.
got to be all done in the next 5 minutes.
Okay,
So,
cool.
yeah.
Well, what I might do, because I think we can come around and you can ask questions, but I just kind of had a bit of a mind blank last night because I was only asked yesterday, Monday, to do this, just about how I think it might impact you, but you guys will know best, right, based on the way that you engage with Māori and what might need to be changed. So in terms of what I think some of the possible implications for the council will be, is that it will create an uncertainty within the law and the way in which you engage with Māori and Māori issues in general. I think it will possibly put in jeopardy any positive work that's gone into building relationships with your local Māori, because you will need to change those relationships, will likely need to change those relationships in terms of how you engage with them. Any co-governance and co-management arrangements you have outside of treaty settlements, and I don't know what those might be, may need dismantling. Your engagement strategies with Māori would likely need to change. I saw that you've got a policy te toi waka whakare. Any policies you have around those relationships may need overhauling. The council on the ground, I think, in the front line would really bear the brunt of the non-recognition of Māori rights and place a strain on relationships, because you become the ones who, when Māori want to protect their awa, are saying, unless it's in a treaty settlement, we ain't even talking to you, unless you're part of the general kind of submissions process that everyone else does. And of course, there's no consultation with iwi or local government on this bill, so there's kind of a process issue as well. Now, if we go to the next slide, I note that this is relevant, and you will likely know more about this than others because you will likely have communications with other councils, but there are councils that are currently, this is before councils currently, I assume across Aotearoa in general, but when I did a quick Google last night, the Hutt City Council yesterday unanimously passed a motion to oppose the principles of the Treaty of Waitangi Bill. And the public reporting, at least, indicated that that motion was to oppose the bill, affirm Te Reti o Waitangi underpins the core work of local government, and reaffirm Council's commitments to its partnership with mana whenua through their partnership agreement that was signed with them, Tākai Here. So there has been a council that has come out on this issue already. I understand Auckland Council is making a decision tomorrow, but what I did was find a paper online that identified some likely themes that would come out from their submissions. So their submissions, assuming it goes ahead, and I don't know, but I just thought it would be food for thought for you to think about in terms of what other how they're positioning themselves in relation to this issue. The themes that they said would likely go into their submissions would be recognition that the bill is unlikely to receive support or to pass, right? But that they would include a high-level summary of the potential impacts to council if it was enacted, so saying how it would impact their relationships with Māori, outlining their existing strategic framework so that the Crown is informed about those impacts and how you currently engage so that they understand the implications. They would provide some comment on procedural issues, including a lack of engagement with Māori and the timing for local councils. They would say general support for robust Crown engagement with mana whenua to maintain the Crown Māori relationship, give support also for a well-developed long-term national constitutional conversation. So that's kind of what we were talking about just before. And in that respect, support better resourcing for the Crown to do more civics education. They'd state that as local government and as an integral part of New Zealand's constitutional arrangement that they should be engaged with, i.e. you should be engaged with, and they'd support clarifying the role of local government in relationship to Te Tiriti. So unsure whether they'll oppose, but that was kind of some of the content and tenor of what was coming out from the paper that I stumbled across online last night around what they might do in their submission. So I guess there's a whole host of, approaches that you could take in terms of like what you want to focus on if you were going to make a submission, ranging from what the City Council has done, which is oppose and say we reaffirm our commitment because we've got this long-standing relationship with mana whenua that we don't want to impinge, to a more kind of here are the implications and we need to be consulted and we support in general more civics education and treaty stuff. So that's kind of a big spectrum of, things that you could do in a submission. Now that is right on 10, but I did want to provide as long as you wanted for a discussion and for you to utilise and ask me questions to the extent it would be helpful in assisting your deliberations.
Oh, kia ora, Natalie, thank you for... sorry.
I thought he went up first, but whatever.
I was just wanting to just follow on from other councils. LGNZ National Council have also confirmed that they will be doing a submission on the bill. Where they would be coming from a point of localism, because that's something that they champion in terms of the impact on the relationships for local government and those councils who have projects that are involved in projects with iwi. They also did do an analysis on the different acts in which it would impact, which obviously is the Local Government Act 2002, Land Transport Management Act, Resource Management Act and the Urban Development Act. So they do have information and they have advised that they will make their draft submission available for other councils to utilise.
I hadn't come across that one.
Thank you, Tony. Wilson, and then Nandor.
Yes, thanks for that. It's been really interesting and informing for me. When David Seymour first brought this bill out, I was personally sort of feeling that he's maybe 50 years ahead of his time. Is the country mature enough to have this conversation yet? Is it 50 years away? But listening to you today, I'm starting to question whether will the treaty ever be, will we, as a nation, will we ever get to a stage where the treaty can be not put to rest, but we all come together, or do you feel the treaty is always going to be at the bottom of our contentions?
I think it's a big question. I have hope that if I think about our tamariki, my daughter coming through, and the whole generation of people coming through who I think will be more educated around Te Tiriti or Waitangi, what it might mean, how we might best give effect to it, I think that there will be a change over time. Like if you look at the statistics coming out around the issues that young people care about, and of course that evolves as they get older. I cared about different issues when I was young than I do now. I think there will be a lot more education around on this front, right? Because if I think about even when I was going through law school, and certainly those that are older than me that went through law school, treaty wasn't even taught, right? Or it was taught in a really limited way, whereas now it's sort of centred to the curriculum and our kids are coming through with a better understanding of it. So I think we will move to a space where down the track we will be able to better engage in what it means. But I think there'll always be a healthy tension there between what it means. And I think as Māori develop, because let's be honest, colonisation has had a huge negative impact on Māori, as reflected in all of the statistics. as Māori start to kind of develop and strengthen their institutions, strengthen their language, strengthen our culture, I think we will be in a better space to understand what rangatiratanga means for us, right? In a context where we're urbanised and we're spread all around the country and what that actually means. So I think there will be, I'm optimistic that over time that there will be increasing recognition and an honouring of Te Tiriti o Waitangi in the modern context in which we live, which is that we have a whole bunch of other people living in Aotearoa as well, and we need to come up with a way of operating in a way that works best for us all.
Thanks. Andor?
Thank you. I mean, it's always been my hope that over time we develop forms of democracy that are kind of unique to here, that marry Western systems with Indigenous systems, and we find something that meets our needs uniquely here. And I think that this cuts across that because it's an attempt to kind of halt progress and stop us moving forward. But it's always been my view that the Māori rights and Indigenous rights don't stem from the treaty.
Yeah, that's right.
They pre-exist, and the treaty, like Tino Rangatiratanga, the treaty affirmed it, it didn't create it. And so while I think that this bill would create a lot of uncertainty and confusion and will certainly hamper us and hold us open for all kinds of legal difficulties, I mean, I think our council's relationship that we're developing with different iwi across our rohe are not just based in Te Tiriti, but are based in our desire for a relationship. And, you know, Indigenous rights, well, I mean, New Zealand is a signatory to the Declaration of Indigenous Rights. So it's not really a question, but I suspect that what will happen is people will just find other ways of expressing their relationships, even if this was to, God forbid, pass.
I agree, but I think what it does is it casts a whole bunch of confusion and doubt into the mix about what you can legally do and you can't legally do. So, you know, you could have a relationship with Tūhoe, because they didn't even sign the Te Tiriti o Waitangi, you know, based on respect for them as mana whenua, casting it in that way. But I still think you would be open to judicial review about how you express that relationship if you were treating them differently to anybody else. That's where I think the legal bite comes in.
Can I just, Can I just question your statement about, did you say that colonisation had a hugely negative impact on Māori? Is that what you said?
I think statistics would bear that out, yeah, in terms of the land taken, in terms of the current status and way that Māori live in
I could
Aotearoa.
argue that and say, well, for many Māori, they are much better off today than they would have been. Well, and there are many that are much worse off. We have this separation which is happening possibly more accentuated in the Māori world than it is in the Pākehā world slightly, but we have, as a nation, we have this problem. So I'm not sure that everybody, I would question whether all Māori were worse off. The country got colonised, I didn't do it, I don't know how to wind it all back. Article 2 is mostly about resources. There are wars going on at the moment, they're mostly about resources. We're now just really, is the hub of the issue here about resources? Is it, and the main resource being land, and when does that ever stop? I'm not even a fan of private property rights, to be quite honest, because I'm just not sure how anyone gets to own a piece of the chunk of the earth, and that's a real philosophical view that I might have. It just seems odd to me, but this is where we are. For better or for worse, we've got this idea that there are private property rights. Māori have lost stuff in the ensuing 200 years, and I guess it gets to the point of another councillor made, where does it ever end? And you talk about a mature conversation, and That's why I come back to what I said before. It's about the spirit of collaboration, and it sort of impinges on what Nandor says. If I'm trying to get on with somebody, those things that were described in the point 6 are the things that determine how I relate to people. I don't want to, so I'm not sure. I could argue that I don't need the treaty as well, which is sort of what Nandor said.
Yeah, I mean, but that's what I said. I think in terms of the impact of this bill, if passed, it could possibly be extensive, but that's kind of the uncertainty around it. In terms of your point around resources, I think resources are only part of the picture, but they are a really important part in terms of what it means to exercise rangatiratanga over land that you no longer own because it was stripped and taken from you, right? And so that's a huge part of it, and part of why I guess Māori still have relevance in Aotearoa, given that they only own like 5% of the land anymore. One of the big critiques about this that has come from a number of quarters is that what it's doing is trying to get the Māori voice out of the way to allow for resource exploitation, because Māori have a particular emphasis and weight because of Te Tiriti o Waitangi that can come through in terms of decisions around natural resources, including petroleum and all of that sort of stuff. And so that's kind of one of the critiques about what this is doing if you step back from it, because unless it's in a treaty settlement, we have no legal weight to place on your voice, right? Whereas I think, anyway, that's kind of part of the picture. So I'd agree with you that resourcing is important, but it's not the only thing covered by Te Tiriti o Waitangi, certainly. And I think that colonisation debate is probably not worth picking up, not because I don't respect your position, but because that could be an argument we have all day.
Well, we could. I mean, I'm not arguing. I'm just saying it happened.
Yeah.
I mean,
Yes.
I just want to point out it's still happening.
Yeah.
It has not stopped.
And that's part of the critiques of kind of a number of the things that are happening at the moment, is that kind of this, particularly the kōrero around any form of recognition of Māori being taken away, not just by this bill, but kind of through a number of different enactments that are occurring at the moment. David Seymour, who's promoting a lot of this stuff, like his position is race is irrelevant, right, and should be irrelevant to everybody. But part of the response to that is that if we don't recognise any Māori rights, interests, or whakapapa relationships with the land that might be distinct, that's kind of the epitome of assimilation. And we've reached that point. But that's just a perspective on it.
would you consider yourself objective and unbiased?
No, that's
coming
why I
into-
said at the start,
Yeah. You're putting a particular view. Yeah.
I think so, but what I'm hoping I'm doing as well is also allowing for the flushing out of whakaaro and ideas in an academic way. I mean, I'm president of Māori Law Society. Part of what we do is around protecting Te Tiriti o Waitangi, its place in the law. So I guess the presumption is that if we want to be a treaty-consistent nation, then you'll look at this in a critical way around whether it reflects what Te Tiriti says. So I think I'm certainly not unbiased, and
No.
we'll say that, but hopefully am reasoned enough to provide a perspective that makes sense as well.
I just wanted to ask too, we've talked about the different relationships and around obligations and the stripping back, which would only allow those who have settled, and we have quite a few iwi that have settled. There would also be an economic impact, particularly for councils. We, in the past, we've had projects in which we're working in collaboration, which also involved funding. That in itself would have some ramifications for our council or other groups or the community itself. Is that a factor, the economic factor?
Possibly. I mean, it would certainly impact the way that, it would likely impact the way you need to engage with Māori. It would likely have a whole host of kind of flow-on effects. I think this is kind of the problem. It's all kind of like, I think it would do this, based on kind of the language. Yeah, I'm not sure about economics. I need to think about that a little bit more. I don't really know how it intersects so much.
I guess based on your comment about judicial review and examples of work we're currently doing in the council, so any co-governance type that we are funneling funding into, if that we were up for judicial review on that co-governance board, that would have an impact. So money spent is now money wasted if we were told you can no longer have that co-governance arrangement.
So, for example, there's been extensive work done, particularly for the Matata wastewater system project that has involved other iwi. So, would that be impacted?
I'm not sure if it's
Because it's co-governance, you've got multiple iwi.
Well, if it's not legislated through the treaty, then I would assume
If it's not
that could be an
legislated through
impact.
settlements, then
Yeah.
it just opens you up to a whole raft of judicial review proceedings if you continue to engage with Māori in a way that treats them differently to anybody else.
Yeah, and that's where I was just wanting to highlight, because if we're in different arrangements already, so we're midway through or we're halfway through something, this piece of legislation could basically open us up wide, or that project up wide, for a judicial review where it could be halted or impacted
Yeah. Yes.
or
that's right.
stopped completely.
I find that discussion a bit interesting because that isn't a co-governance situation at Matata Sewage. It started off as one, and iwi didn't want it to be co-governance. They wanted it to be co-designed so that they still have the right at the end, or they recognise the fact that the council has to make the decision, they can't. So we did co-design where it was involved right from the very beginning. And so I would have thought that we have, this council, I know in other councils they've gone backwards, but I would have thought in this council we've made such great gains in relationship that you just call a different name and keep going, and with full relationship with local iwi, hapu, etc.
But I don't think it matters what you call it. Like, it will be, if a court is looking at it, it will be whether you're treating them differently
To any other group.
Whether you're calling it co-governance or not. I think Nandor raised a really interesting issue just around, like, is your actions in relation to them anchored into tiriti or Waitangi, and kind of what flows from empowering provisions in the Act, or whether it comes from somewhere else, because if it comes from somewhere else, you could argue that it's different. But what will be interesting is what a court would do with what is supposed to be a pervasive way of looking at Māori interests in general. So there'd be a lot of time that's needed and legal testing of actually what all of this means. And it'd be interesting to see what a court would do with that kind of context.
So,
Look, I have to go to a funeral, but thank you very much. I've just
No worries, thank you for listening.
looked at different things. Thank you.
Julie has a question.
Sorry, Julie does not have a question.
A
Julie
comment.
has, you obviously need some guidance from us in regards to the submission.
Well, yeah,
I
don't, unless you're wanting me to help with that.
Otherwise, we could be here all day. So my comment is the fact that I'm happy to support a submission opposing the treaty principles bill, and a lot of the justification and reasons I think you have outlined on your summary of the key issues to be able to go towards justifying our opposition. So that's where I stand, because you're looking obviously for something from us today for that. So
Can I ask you a question about Winston Peters' view?
Sure.
There are no principles in the treaty.
Yep.
Which really comes down to what you said before about this view that the treaty could just be interpreted without extrapolating to principles, which I actually quite like that idea.
Yeah.
So I would oppose the bill but maybe not for the same reasons that everybody else would. And I'm also a fan of Apirana Ngāta's, and I've read his explanation of the treaty many times, and I could probably read it a few more times and probably still not get it all, but I'm not sure where he...
No, I'm happy to comment on that. I'm not entirely sure of Winston's view. I just sort of pick up bits and pieces from the media. But so I'm not... They're interesting, right? Because they've got a different arrangement with the government around what they intend to do with the treaty clauses that currently exist in legislation. So you've got David Seymour, who's wanting to pass this piece of legislation, and then you've got Winston Peters and co, who their position is that we're going to go through and have a review of every piece of legislation that mentions the treaty, and we may look to make changes in a big sweeping piece of law as well. So that's another thing to look out for, because what they're wanting to do is, so for example, with the RMA or the Local Government Act or whatever, review each of those and see whether it's operating, how it's operating, and either look to remove that clause entirely or further define it. So that's kind of another big piece of work that's currently happening, that we don't know where it's going to end up because it's still in the review phase. But I think, New Zealand First proposed a piece of law ages ago around getting rid of all references to the treaty from legislation, I think. But I'm not sure of whether it's because he thinks you should uphold Te Tiriti o Waitangi or whether he just doesn't like the treaty in general and wants that removed. So I'm not sure about that. In terms of Apirana Ngāta, he's quoted quite often. I'd be quite cautious actually about relying on Apirana Ngāta, not because he's not an extremely respected Māori Ngāti Porou person, but he was operating in a very particular context when he was making those statements. And it was a context where he wholeheartedly was trying to convince Māori in a context where he saw his people, really culturally grounded and that sort of stuff. He was trying to convince them that the tools of the Pākehā were a good thing for Māori, right? And so I think I don't think even Ngāti Porou would actually adhere to some of the statements that he's actually came out and said about Te Tiriti o Waitangi, because he was taken at a very particular time making particular comments around that aren't consistent really with kind of most other kind of accounts of what was ceded and what Te Tiriti o Waitangi actually meant. Yeah. So I respect him and I think his writing is beautiful, but on that particular kaupapa, I would be cautious.
Just that I interpret it as explanation. He's trying to explain to the old lady on the marae what really this was all about.
Yeah.
And I mean, it is written in a lovely way, and I sort of hold to it a bit, but maybe it's because I haven't read widely enough, but I have read that.
Yeah.
So if we default back, this bill was only going to go to first reading supposedly, and then that's going to die.
Yeah.
And so we object to it. It doesn't go anywhere. We default back to what we're doing.
Continue to do. Yeah, that's right.
Which, is that okay?
I don't know. I don't quite know how you're operating at the moment. So ask Tim from Natia.
Well, we are trying to. I think we're operating in the spirit of collaboration. You can call it partnership. I always talk about collaboration, but and I think it's actually working quite well. Is it too? Is it working all right? Yeah. So we do. So if we don't want to change anything, we just Tony.
I just want to confirm that I support, thank you to Julie and also Victor, I support our council making a submission in opposition to the Treaty Principles Bill. I think to be able to provide confidence to the relationships that we have currently at the moment, even though it may not pass through to the next reading, the tension and damage that it's already currently doing through this whole process itself. And as a council, we do need to look after the whole of our community and ensure that those relationships are looked after. And this, by making a submission to oppose, provides some form of confidence of that relationship. And for me, just getting a better understanding today around the legal implications that this could have, particularly that we have 7, well, we've sort of got 8 iwi here, and it all intersects in everything that we do in council, and whether it's our roading team, whether it's, anything. We also too have to understand that we are integrated not only as an organisation relationship, but the descendants of the iwi work for this organisation and are in this organisation everywhere. So there is a human element in terms of the impact of that relationship and how that would play out if our staff are frontline having to deny their own people the ability to have a say in something here in our community. So in short, I'm really grateful for the analysis that you've provided us. There has been so much information everywhere that's floating out, so it's good to hear the perspective and impact directly for us here in our council. And thank you to you all. Kia ora.
You're on the clock.
Yeah, I'll be, yeah.
Would you like to join us for, there's 2 questions there on the floor, so we'll get to them and then I'll ask you if you want to stay for morning tea and if we'll be charged for it. Leslie and then Napera.
Morning, Nanga Aminga Nahi, Natalie. Hi, everyone. Well, I am recovering okay now. I've lost my voice, so I better not come and share. Thank you so much, Natalie. It was a really great summary. It was as I was kind of what I had read and how I'd interpreted, but I think the questions that the other councillors have given and your explanations have really added lots of value. And of course, our relationships going forward with iwi by us opposing the bill with our submission will add lots of value with our wider relationships. So thanks very much.
Kia ora. Napera.
Hey, kia ora, Natalie. Thank you for that breakdown. Just a bit of context. Tūhoe didn't sign the treaty only because they put their meetings in places where we did not have roads in those days, and by the time you get the message, they've moved on somewhere else. But in the same context, yes, we have been operating without a treaty, and we have never ceded our sovereignty, but it does not, going back to you, but it does not stop those relationships and collaborations and what that does look like. So in terms of the question, I am happy to support our submission from the District Council to oppose this bill, and that's really based on the continual relationship that our Kotuia team has built from the council and its objectives of strengthening those relationships. I suppose you can look at the treaty. If there's one thing that I've learned, and I think we all learned, that when we come on, even as a community board member, or even when we are inducted as councillors, we actually read an oath. And that's an oath. So that oath gives one. It's a piece of document that gives us that recognition of our position. That is no different than the treaty principles. The treaty, that is our document that that has to be worked through. And its significance to our people. We form great relationships, and I'd just like to see that continue, but I would absolutely reject the bill. So thank you, Natalie. You got to go. Guys, I've got to go. I've got to head out to Murupara. We have the Regional Council Rate 10 coming over, so I'm going to support our community and navigate that space. So ngā mihi atu ki a koe, ngā mihi atu ki a tātou.
Kia ora.
Kia ora. I guess we better draw a line here. You're welcome to join us for morning tea, and I'll conclude the meeting. I'm sure the discussion, I could carry on talking about it all day, but I'm supposed to be somewhere else too.
I won't stay for morning tea. I've got to catch a flight, so I'll head over to Thing. But thank you for inviting me here. Happy to be of any further assistance on anything. I'm local, so just up the road. I live up on the hill, so happy to help out with whatever, and good luck in your deliberation.